Court, all rise. Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I am Justice Rubin, and I am fortunate, and you are fortunate, because I'm joined today by two outstanding colleagues. To my right, Justice Massing. To my left, Justice D'Angelo. We will be hearing, the court will be hearing 6 cases this morning, although for the last one, there will be a change of panelists. The first matter we will be hearing, I should say the rules here, in case you're not familiar with them, are 15 minutes per side and no rebuttal. In the event that any parties are dividing their time, you should let us know at the outset what that division of time will be. Our first case this morning is number 20-970, Commonwealth versus DESALVO, and we will be hearing first from Attorney Allen.
Good morning, Your Honors. May it please the Court, Ashley Allen on behalf of the defendant appellant, Mr. Sean DESALVO. We have 2 issues on this appeal. The first issue deals with the withholding of exculpatory evidence by the Commonwealth in a particularly disturbing manner. And second is Mr. DESALVO is entitled to a new trial because of 2 sets of medical records that were admitted, that there were numerous statements within them that pointed to the diagnosis of assault by the complainant's boyfriend, who is identified as Mr. DESALVO at trial. So if Your Honors have no particular preference into which I will address these issues, I'm going to first address the withholding of evidence by the Commonwealth. In this case, there was one witness, and it was, well, one percipient witness. It was the defendant's girlfriend of approximately a year and a half. And there was a 3-page written victim impact statement.
Can we just, so I've read the statement, and it's, clearly under mandatory discovery, it's a statement of a witness. Your client was entitled to get it. I don't know if it's necessarily exculpatory, because it's like, he did this, he did that. It's actually, certainly if they wanted to put that in as if the Commonwealth wanted that as an exhibit, you would object. So it's not exculpatory. So could you explain that sort of the distinction?
Well, it doesn't need to be absolutely destructive of the Commonwealth's case. Here it's exculpatory because it provides some sort of significant aid in that these were inconsistent statements. And so the Commonwealth and I have different views on whether or not it's
okay, so let's say there's stuff in it that is exculpatory. I think there is at least one thing and maybe 2 that are, I don't know if they're exculpatory, but that I think come within the rubric of exculpatory. The first is this one punch or multiple punches.
Correct.
Okay, so certainly you could cross-examine the witness using that, and to the extent that it does something to undermine her credibility, okay, let's call it exculpatory. If you had done that would the Commonwealth not be permitted for the jury to understand the context of that statement? That is, that it's not testimony going through line by line each thing that happened. It's a victim impact statement that's more, that is an inconsistency, but it's more impressionistic. It's not designed for exactly the same purpose. And that might be their explanation for why you shouldn't take very seriously this unsworn victim impact statement compared to what the witness said on the stand. So my question is, if well, two questions. The first is, wouldn't your use of this open the door to the Commonwealth introducing the whole statement? And if they did that, wouldn't that be terribly damaging to your client rather than helpful?
I don't think that it opens the door to the entire statement. I think that there's an argument there that they could cross-examine or, ask her additional questions about that. Maybe eventually, the majority of the statement getting in through questioning. Regardless, the defense was that this credibility of this witness is problematic. And you have what she testified to and what she wrote in words in which was closer to time to the incident. It was a year prior to trial, arguably more detailed and reliable. And so that would have been up to the defendant to use that. But because he didn't have this,
but
he
they
couldn't
would
make
also
those
then
decisions.
hear something she can't do on the stand, which is her repeating her allegations, and not just that, maybe talking about the profound harm done to her. I mean, right, if I showed that to any defense attorney and said, would you like this to be admitted, this document, I think it's obvious you'd say, like, no, I don't want that to come in.
So those are reasons why the entire statement would not be admitted in its entirety.
Well, no. The fact that you don't want it to come in doesn't mean it doesn't come in. Lots of evidence you don't want to come in comes in. I'm just thinking that, I don't know if it's a matter of verbal completeness, right? So there is that doctrine of verbal completeness about statements. And I'll ask counsel on the other side about this too. But there's also the question of the context in which the prior inconsistent statement was made. And wouldn't you have to show something about the tenor? Wouldn't you be allowed, if you were the Commonwealth, to show something about the tenor of this document, what it's for, how it's going to be used, and to show at least substantial parts of its contents so that the jury can understand, oh, I see, that was a victim impact statement. It's not a comprehensive overview of every incident.
Right, and had it been disclosed prior to trial, not at sentencing, then that would have been up to the trial attorney to decide if he was going to.
But we have to figure out prejudice.
Right, and so here, let's take some other examples of the inconsistencies. So the very first one is that she testifies he was going to shoot himself and then he was going to shoot me. The statement that is in the victim impact statement is that he was only threatening to commit suicide himself.
That's not inconsistent.
So
right?
there's no crime alleged in the victim impact statement.
I agree with that. But it's not inconsistent that in an incomplete statement that she might say that what struck her most about that incident was that he was threatening to kill himself. I mean, we don't know because she was never cross-examined with it, but it's not actually inconsistent. It's not complete, maybe, and that's an argument you have. You have an argument, once you make the argument, there are two incidents that she doesn't mention at all.
Right, and those are things that...
Okay, but now, then what does she mention? Ladies and gentlemen of the jury, here, read the whole thing, and you'll see that this isn't the kind of thing where you necessarily mention every incident. And enjoy reading it, too.
Understood. But I think when it comes to prejudice, this was an undisclosed statement by a victim that was arguably more reliable considering the time in which it was written. And it goes directly to vital aspects of the case, in which the Commonwealth doesn't deny. I think right there, Tucheri or Tuseri says that is prejudice. The defendant is sitting here with, I asked for specific statements of a witness. You told me and represented to the judge.
You think that for purposes of considering prejudice, we don't try to figure out how the whole trial would have been different if this had been turned over?
I do
think
that
we do. So we do need to figure out what the Commonwealth might have been able to introduce, because if its harm outweighs the benefit to you of the cross-examination, then maybe this isn't prejudicial to exclude it, right?
Well, I think that when you see that the defendant was acquitted of one of the counts, which was the firearm offense from the first incident, the jury clearly didn't believe everything that this witness said. So they may not have believed everything that her victim impact statement said. So even if it was to come in its entirety for completeness purposes, I don't think we can sit here and be confident that the jury wasn't going to consider this any more so than her testimony or vice versa. They could have taken it in piecemeal and said, she was very, there was medical records admitted, and I believe her on this charge, but I don't believe her on this, especially too when, for one of them where she says for the February 5th incident, which you do agree is somewhat exculpatory, where she says that he was repeatedly punching me in the face. Well, at trial, she said, I remember this because this was the very first time that he hit me. He punched me square in the face. It was one time. That's it. He didn't punch me anywhere else. And then you have a victim impact statement that's saying he's repeatedly punching her in the face. And that was the very first time he ever hit her. And so, of course, that stands out in her mind.
What about the fact that the trial judge on a motion for new trial considered the statements that were in the victim witness impact versus what happened at trial, and he found that it wouldn't have made a difference? How can we utilize that, if at all?
Well, I think it being an abuse of discretion standard, you do have to consider that he was the trial judge. But at the same time, he's saying that this isn't deliberate, and so therefore, the standard review doesn't, it would have made no difference. You as judges can look at these statements,